Hi, welcome to the first of many short voiceovers of the documents that you're going to use in the Youth and Government Appeals Court this year. Again, biggest difference this year is the appeals court is going to be separate from the trial court, and so instead of just participating one time, you will participate several times depending on the number of teams, and you certainly want to be prepared to do both sides of the case. So I'm going to try to keep these between 5 to 10 minutes long. So the first one I'm going to do is just go through the stuff that's on the website for Youth and Government, and it's called the problem or the case problem. And that has the case with the appellant and respondent briefs. This is the first thing that you want to print off, and by far the most important thing that you'll need in order to be successful. So basically what you can see is that this is a case in which the appellant, meaning the people who are bringing the case before the Supreme Court, are Abercrombie and Fitch, and so that they're the appellant when we use that term, and the Equal Employment Opportunity Commission, and I'll use the term EEOC a lot, are the respondents. And so those terms are extremely important. What you'll see is that this is a case concerning potential religious discrimination, and the situation is where a young lady who is Muslim applied for a job at Abercrombie and Fitch, and ultimately because she was going to, or at least the assumption was she was going to wear a Muslim head covering, that violated what was called the look policy, basically the dress code of Abercrombie and Fitch, and because of that she was denied that employment. She was never hired. So basically, if you've not done appeals before, here's the way it's going to work. The case is divided into two questions. And those two questions are, first, whether Abercrombie was sufficiently, and the phrase is, notified of the young lady named Eloff's religious beliefs, and that they conflicted with the look policy. And then the second question was, even if Abercrombie had notice, then would accommodating Eloff's religious belief impose what's called an undue burden? So just again to give you an idea, the way teams work in the appellate court is you typically divide your team, and you should divide your team based on those questions. So one of you should deal with the notification question that we'll be going over. The other partner should deal with the undue burden question. And you want to be able to argue that question on both sides, both for the appellant, Abercrombie, both for the respondent, the EEOC, who is representing Eloff's position. And you will have, and this is not in this document, it'll be in the rules document that'll get posted later. You'll have 20 minutes as a team to argue that, and you decide how that time is divided. So it can easily be a simple, one question is going to do 10 minutes, the other question will do 10 minutes, but you decide that. The only thing you want to consider is when you are the appellant, you will also have the ability to use, within that 20 minutes, 5 minutes of rebuttal time. And again, that is up to you. So for instance, a typical appellant might be that we're going to use 8 minutes for the first question, 8 minutes for the second question, and we're going to leave 4 minutes for rebuttal. If you are the respondent, you don't have rebuttal, so you'll just divide that 20 minutes. But the key thing is you both have 20 minutes, both appellant and respondent, regardless of whether you have rebuttal. The rebuttal time comes out of your 20 minutes. And again, the key thing is we're going through, if you are taking the Abercrombie side, you will be labeled as the appellant. Sometimes we use the term petitioner. If you are on the EEOC, meaning Eloff's side, you will be the respondent. So as you go through this first document, you have a statement of the case, and this is really important. Basically, the statement of the case are the facts of the case. I'm not going to read those for you. You'll see that I'm just scrolling through that at this time, but you want to be as familiar as possible with that situation. And again, the key thing is there are several important things about Eloff's application for the Abercrombie job and the interview process that she goes through. That's very important, and you'll want to read that carefully, and both partners should read the statement of the case. You can see that there is some testimony that was part of that case. You can see here that there was a district manager, a woman named Gannett, who is a very important part of this case. and she testified. Several of the Abercrombie executives are testifying in this case. And so this continues on through. And basically, just to give you an overview of the questions that you're going to see here, is the notification question really turns on 2 points. One, if you're taking the Abercrombie side as you're reading, you want to see if there's any evidence that Eloff actually notified Abercrombie that she had this religious belief, that she, as a Muslim, she wanted to wear a head covering, and did she inform Abercrombie directly of that? You're going to see there's not a lot of evidence of that. On the EEOC side, or on the Eloff side, it is clear that Gannett, the person who did the interviewing, did seem to be aware of the fact that Eloff was a Muslim and that wearing a head covering was probably for religious reasons. That's going to be a big part of the notice argument. The undue burden argument is just the idea that if Abercrombie were to make exceptions to its dress code, what it calls its look policy, as you can see here, would that create an undue burden? And we'll talk more about that as we go along. So you want to be very familiar with the look policy. You can see that that takes a little bit as we continue with the statement of the case. And then you've got a statement of legal principles. Again, this is basically the facts of the case. You want to be really clear on Title VII of the Civil Rights Act, and you can see as you go through that. And then the EEOC is the part of the Justice Department that enforces the Civil Rights Act of 1964, and specifically that related to employment, which this one is. And so you want to go through that and be familiar with how they enforce, especially the religious discrimination. And then the most important part of this document then is the actual appeals case. So I'm going to be stopping this video in just a second and going through this a little bit more directly with you. So again, just to overview what we've done so far, the key is if you wind up representing Eloff, which is the EEOC part of this, you will be the respondent. If you are representing Abercrombie and Fitch, you will be the appellant. Each team will have a total of 20 minutes to argue their case. You will divide that between your two team members. Remember that the appellant can use part of that 20 minutes, a maximum of 5 minutes for rebuttal. You will indicate before you start your case how you're going to divide your time. And the key thing in this first document that we had is you really want to read carefully the statement of the case, the statement of the applicable legal principles. That's going to basically be the facts of this case. If you want to see this kind of like a criminal trial, this is really the testimony, the facts that we then argue based on constitutional issues that we'll start talking a little bit more about in a second. But I'm going to go ahead and stop this first tape here and then do another short overview concerning the appeals case itself.